A recent European court decision that seemed to be about social media privacy has kind of quietly turned into one of the biggest deals for the entire artificial intelligence industry. It's a case that is fundamentally rewriting the rulebook for how AI is even built. So let's just start with a single most important takeaway. The Court of Justice of the European Union, in a case between activist Maximilian Schrems and Meta, dropped this bombshell. And while that sentence might sound simple, trust me, its implications are absolutely massive for any companies scraping data from the web. And that's because what started as a fight over targeted ads has now sent this huge ripple effect across the entire world of AI. The very foundation of how many of these huge language models were trained, it's now on some seriously shaky legal ground. To really get the full picture here, we're going to break this down into 5 key parts. We'll look at the case, we'll bust a long-held myth about public data, dive into a critical legal idea, see how this all sets the stage for new AI laws, and finally, lay out the new rules of the game for AI. Okay, so let's get into the case that kicked all of this off. It was all about how Meta uses our personal data from its services and partner sites to build those hyper-targeted ads. But, and this is the key part, the court didn't stop at advertising. Its conclusions went way, way further. The first major casualty of this ruling is a core assumption that has basically fueled AI for years. We'll call it the public data fallacy. The idea was super simple. If data is public on the internet, it's fair game. Well, this ruling completely demolishes that idea. And the main tool built on that fallacy is web scraping. I mean, for years, this has been the engine behind the whole big data revolution. It's allowed companies to just hoover up incredible amounts of text and images from every corner of the web to feed their algorithms. So what we're seeing here is a huge legal shift. We're going from a kind of Wild West approach to this new critical idea of contextual limitation. The court is basically saying that the context, the reason you shared something, is now legally binding. So here's the bottom line. Your purpose matters a lot. When you post a photo for your friends or you write a comment, your goal is social communication. The court is saying that doesn't give a company implicit permission to scrape that content to build a brand new commercial AI product. This has a direct impact on your data and what can be done with it. And this leads us right to the legal machinery behind the ruling. It's not some new law they just invented. It's actually the strict application of one of the GDPR's most powerful ideas, but applied directly to the world of AI. It's a principle called purpose limitation. And put simply, it means you can't do a bait and switch. You can't collect data for one reason, like running a social network, and then just turn around and use that same data for a totally different, incompatible reason, like training a new AI to sell. And the court made this crystal clear. They said providing a service for people to connect is one thing, but using their data to build an entirely new commercial product, that is a fundamentally different purpose. And under the law, the two just aren't compatible. This ruling also takes apart a really common legal argument companies use, claiming a legitimate interest to process our data. The court basically said, look, when you're scraping such massive, disproportionate amounts of data, purpose limitation comes first. Your business interests don't just get to override people's fundamental rights. So now the consequences start to get even bigger. This isn't just a ruling about the past. It's actively setting the legal foundation for the European Union's huge new AI Act. It's creating this powerful link between existing data protection law and the future of AI regulation. Yeah, the best way to think about it is that this ruling is now a prerequisite. The new AI Act requires that AI training data follows the law, including data protection laws. And this is where a classic legal idea called the fruit of the poisonous tree comes into play. It's a really simple chain of logic. If the data you used was collected illegally, that taints the entire process. So the AI model you build with that data is now built on a legally toxic foundation. It is the fruit of a poisonous tree. This logic leads to a pretty terrifying question for the multi-billion-dollar AI industry. What happens to that fruit? Could a regulator actually order a company to destroy its own AI model? And the answer appears to be yes. The ruling opens the door to something called model disgorgement. It basically means regulators could force a company to destroy an asset it created illegally. So the risk isn't just a fine anymore. It's the very real possibility that a regulator could demand the complete destruction of a hugely valuable AI model. Okay, so what does this all mean for the future? How are AI companies supposed to operate now? Well, it forces a complete, total strategic shift in how they have to think about data. We are really seeing the end of the big data era, this idea of just indiscriminately harvesting everything you can find. The future is curated data. The new game is all about quality, legality, and verifiability, not just raw quantity. So for AI developers, this lays out a clear new playbook. They either have to build their models using licensed data, or they have to get very specific, separate opt-in consent for AI training. For all of us who use these tools, it means more transparency and more control over how they're made. And the court got incredibly precise on this. In this case, Mr. Schrems had publicly mentioned his sexual orientation at a panel discussion. The court ruled that that single disclosure in that one specific context did not give Meta a free pass to then process all the other data it had about his orientation to target him with ads. And that example really gets to the heart of it all. This is the big takeaway. We are moving from a world where public just meant free to use to a world where context is absolutely king. How, where, and why you shared your data is now the most important legal factor. So this ruling doesn't just create new rules, it forces a really profound, almost existential question on the entire industry. You know, the first great wave of AI was built on this assumption of near infinite free data. Now that that assumption has been shattered in Europe, it forces all of us to ask, what will the next generation of AI actually look like?